Hello, everyone today. Beautiful spring day here in Syracuse. Hope you're having a good day wherever you are. I'd like to first start off with a reminder that I do every week that we have our workplace seminar coming up in all these cities very soon. Hope to see many of you there in person. And go to our website, register, and come see what we have going on that day. We have a full day of content all about labor and employment law. Moving on to today's agenda, it's a very much a focus on new things that you should be aware of. After a long-awaited process, the New York State budget is finally complete. In fact, the last pieces of the budget bill were signed by Governor Hochul today. So this is very, very fresh news. And there's a number of items in there that are important to our clients. Some in the labor law realm, which is my part of the world, and I'll talk about that first. And then we have Roger Bearden in our Albany office, a veteran of state government who is very familiar with the process and focuses in the healthcare area and wants to talk today about some key impacts on health service providers. There's some significant developments in that area as well. And then we will come back here to our Rochester office, actually. Our associate Stephanie Fedorka is here to talk about some EEOC regulations that just came out on the Pregnant Workers Fairness Act. That's a law that will be going into effect very soon, and so need to be aware of what those regulations say. I think we may have presented on the proposed regulations on this program a while ago, but now these are the final regulations, so wanted to go over those today. And then finally, last but not least, down to Westchester, which I would consider downstate. Other people would consider upstate. But in any case, Andrew Delzato is an associate there in our office. This is his first time on the webinar. We're happy to have him. But he recently wrote an article about a case that was decided that addresses the application of the state and city human rights law to out-of-state applicants and employees, something, and with many people's workplaces being spread out across the country, very important to know what happened in that case. So with that long-winded introduction, I will talk about my piece of things. Like I said, the budget, usually it's due on April 1st. It was late this year. The topics that hung up our lawmakers didn't appear to be so much in the labor area, but in housing, that was a large area of discussion. I'm not going to have a chance to cover that today. Again, this just came out. It's all very new. We're still digesting it. So my disclaimers, there may be other labor pieces that are interesting that I haven't gotten to yet. And if so, we will present on those in future weeks. But for now, these are the really big ones. Kathy, if you could go to the next slide. And if you're a regular attendee of this webinar, none of this is surprising because I talked about Hochul's proposals that came out in January, and then the one House bill that came from the legislature, I think in February or March, talked about that. And now this is the final. After that whole process of going back and forth, this is where we ended. The first big one is paid prenatal leave. According to the governor's office, this is a first in the nation type program. So the way it was done, and there was some debate through the legislative process, there was a debate of whether they would amend the New York Sick and Safe Leave law, or they would add this as a permissible use of paid family leave, an insured type benefit. But where it landed was that it's not insured, that it doesn't go through PFL, and instead it's just a benefit that all employers, I should say private sector employers, have to provide. So basically the law that says that you as a private sector employer must provide sick leave, they tacked on an additional requirement to provide 20 hours of prenatal leave. Again, in addition to what you already do. So you cannot ask an employee to use their sick leave accruals for this purpose. It's an additional 20 hours. A couple things of note. First of all, we have some time to get ready for it. It does not go into effect until January 1 of next year. So 8 months or so to get your handbooks up to date and fix your payroll system so you have a code for this type of leave. It says during any 52-week calendar period. I actually find that language a little confusing because when we talk about calendar year, we typically mean January to December. And I'll be honest, when I first read this, I thought, okay, calendar year, which doesn't make sense because if a pregnancy crosses over from December to January, technically the person would get 20 hours in year 1, 20 hours in year 2. That doesn't seem right. But looking at it closer, it does say during any 52-week calendar period. I think what that's going to mean, and we're going to look for guidance from the New York State Department of Labor. I think what that means is more of a rolling 52 weeks. Not 100% clear, don't hold me to that. We have until January 1st to figure it out. But that's one question that jumped out at me. And then it talks about the permissible purpose of the law or of the leave. And I quoted it here for you. Leave taken for healthcare services received by an employee during their pregnancy or related to such pregnancy, including physical examinations, medical procedures, monitoring and testing, and discussions with the healthcare provider related to the pregnancy. All typical stuff that one might encounter in a prenatal visit. The one question mark I have on this is when it says during their pregnancy or related to such pregnancy. That sort of implies it's something beyond just during the pregnancy. Because why would it say or related to? So these are the types of statutory interpretation things that we do as lawyers. And so I'm interested in whether the State Department of Labor will give us any guidance as to whether it includes prenatal, for example, infertility type treatment time, or after maybe the loss of a pregnancy, abortion procedure, those types of things. Just remains to be seen. Of course, an abortion procedure, I would think, would be covered because it is during the pregnancy, but what about follow-up for that? There's no longer a pregnancy, but maybe that's where the or related to such pregnancy comes in. These are the questions swirling, but stay tuned. As always, we're always paying very close attention to these things so we can give you the best guidance possible as this year progresses and you have to, write policies and implement policies. So that's the first thing, paid prenatal leave. The next thing is also a leave. That is the theme here. Next slide, Kathy. So after the pregnancy, I'm just realizing now what a theme we have today with Stephanie's topic. But so the next topic is paid break time for breast milk expression. We already had a law in New York State, Labor Law 206C, that we've talked about many times on this program, talking that requires an employer to provide an employee who is expressing breast milk. What it previously said was you had to provide reasonable unpaid break time or permit an employee to use paid break time or mealtime. So no extra requirement to provide extra time, just unpaid time or use the breaks you already get. Each time the employee has a reasonable need during the day. The amendment says the following, and the bold and underlined sections, those are the changes. So what the budget legislation did was it changed reasonable unpaid break time to say paid break time for 30 minutes. There you go. So now there's a requirement that you must provide employees paid time for 30 minutes. Now, interestingly, in Governor Hochul's proposal, it was 20 minutes. It actually went up through the process. So I just find that interesting. That must have been an important issue to some enough to push for more time. And then it also changed the or in the first paragraph, or permit an employee to use paid break time, to an and. So you have to provide the paid break time and also allow the employee to use other paid break time or meal time. And then they changed the her to such employees, I think getting away from specific gendered legislation. And then finally, this isn't a change, but I want to point out that the law says that this has to be provided each time such employee has a reasonable need. That quite certainly, maybe not certainly, but it's likely that would be more than once a day. And those are questions that we're going to have to kind of figure out. How does that work? It says each time the employee has a reasonable need. Who determines what's reasonable? What if an employee says, hey, in my particular medical situation, I need to express breast milk once an hour? Is that reasonable? Who decides? These are questions we're going to have to figure out, because before, when it was unpaid, not a lot of, I don't mean to be cynical, but incentive to ask for more than what was needed. Now that it's paid time, if I am being cynical, maybe there's a motivation to ask for more breaks than maybe might be needed. Something we're going to have to just figure out hopefully my cynicism is undue and not necessary, and people, you know, are all in agreement on what's reasonable, but just wanted to point that out. In terms of timing, this one kicks in a little faster than the other one. This goes into effect in 60 days. It was signed on the 20th over the weekend, and so the implementation date for this law is June 19th, pretty soon. So would recommend that you update your policies and provide appropriate notifications to the employees that this affects. You should already have a policy in place. There was a model policy that New York released within the past year that we've talked about. I think I talked about on this program. I think it was my topic that day. And so that will just need to be tweaked ever so slightly. If you used just the written policy from the state and attached it to your handbook, which I think a lot of people did, that won't quite be accurate anymore. So we will be looking to see whether and when the State Department of Labor issues a new one. I'm anticipating they will. I don't think that would leave an out-of-date, incorrect policy on their website for employers to use, but I don't know when. They've got 60 days, and sometimes it takes them a while. So that's what I have on this piece. And then the third one that came out of the budget process relates to COVID leave. And we've talked extensively here on this program. The genesis of this program was COVID. Kathy, next slide. Drum roll, please. COVID paid sick leave will end, but not until July 31st, 2025. When I first saw this on Saturday morning, I thought that must be a typo, but then I thought they don't usually put typos of that sort in the budget bill, and I haven't seen any correction. So indeed, for some strange reason during the legislative process, the expiration of this law, I was almost going to use a pejorative term to describe the law, but I'll try not to do that. This law sticks around for another year to July 31, 2025. Now, we've talked about it before. We've written about it before. It's really confusing on how to apply this now that the state doesn't issue any orders of isolation. You know, there is an argument that the law just doesn't even really apply anymore because of that. But now that the state has put in their budget that it stays in effect until 2025, it becomes harder to say it just doesn't apply anymore. We're going to spend some time here at Bond thinking through this and what the best approach is. But the easy answer of it just expiring, unfortunately, is another year and 2 months away. But then after July 2025, we're done with that. Now, that's my last slide, but I just want to mention a couple things that did not make the cut, because in my original presentation back in January and the article I wrote, I talked about two or three other things. None of those made it into the budget. So we're not seeing any increases to the amount of paid statutory disability leave, state disability leave. So that benefit that's required by New York State is still $170 a week. And it stays there. There seems to be support among the legislature to increase that. Many people agree that it's just still not enough. It has not been updated since 1989, but it did not make it through the legislative process. There's nothing in the budget bill about it. The other thing was we've talked about what happens for a claim of a wage claim for manual workers who aren't paid on a weekly basis. There was a legislative proposal just to make clear that if the employee is actually paid, just not on a weekly basis, they don't get liquidated damages. They don't get to double their money, essentially. That fell out of the budget. That did not make it into the final version as well. So we're left with some uncertainty in that area that will have to be fleshed out by the courts. So that's actually all I have for now. Like I said, still examining the budget bill. It's hundreds and hundreds and hundreds of pages. If there's anything else of interest on the labor front, I or someone else will report on it. We're still digesting other aspects of it because I know that labor is not the only area that our clients have interest in. It just happens to be my area of interest. So we will keep reviewing it, and I anticipate a series of presentations over the next several weeks. But before we do that, we have another presentation today, as I mentioned. So I'm going to turn it over right now to Roger to talk about key impacts on human service providers. Thanks, Roger.
Kristen. You have an incredibly popular presentation there. I can see 17 questions in the box. So I think we're going to make an attempt to get to some of those maybe at the end if there's time remaining. But others should know that they can. We'll get a follow up. This sounds like there's a lot of areas for interpretation and question
Yeah.
in this area. And as Kristen mentioned, I have a veteran experience in state government, so I've had some opportunity to see how the sausage is made, to use that tired analogy, and certainly sometimes what comes out is not necessarily entirely logical. So, in terms of human services, and we use that term to describe the broad swath of entities that support New Yorkers who have needs and are generally in reliance on government supports in some way. Three major items, one of which bridges a little bit into the labor space. There was substantial advocacy with respect to a cost of living adjustment to increase the support that's available to those providers to provide their services. And the governor's original proposal, there was a 1.5% proposal. There was substantial advocacy across a number of sectors for the number to be 3.2%, with an additional $4,000 that would have been allocated directly to workers in a sort of splitting the baby compromise that appears. The end result was a COLA of 2.84%. And then a requirement that 1.7% of it be allocated to direct care, clinical, and non-executive administrative staff. This is a kind of initiative that would have been familiar. There were a number of allocations made, particularly during the COVID period, where the monies were to be made available only to specific types of workers. And the budget bill goes on for some period of time because different industries may code their workers in different ways. I would expect each of the state regulatory agencies, there's usually half a dozen that are going to be involved, putting out specific guidance as to how those allocations of those funds, and then there will be probably some traceability requirements to show that the providers in fact allocated the money in the way that is required under the law. The previous mechanisms that the state tended to use were attestations from the providers, as well as some data reporting. What happens next is something that we will be closely monitoring. In unalloyed good news, at least for behavioral health providers, a proposal that was originally in the governor's budget to require the payment to those providers by commercial insurers be at least as high as the Medicaid rate did become law. In that sector, Medicaid typically is a better payer than commercial insurance has been, and that's been easily a decades-long fight to try to require those insurance companies to provide at least the level of payment that the Medicaid program provides. And so that will be lost. The major, I would say, low light of the budget from the perspective of human service providers is a rather dramatic change to the consumer-directed personal assistance program. That program is a form of home care where the people who are being served, the consumers, are able to direct their own care. They have the assistance of an entity called a fiscal intermediary, which is an entity that helps with certain back office and payroll functions. There's around 700 such entities in the state, and the governor's enacted budget says there will be one statewide fiscal intermediary. So certainly for those companies, there is a dramatic impact to their business. This is actually the third time. There was a 2019 effort to narrow those businesses through an initial request for offer process. There was a second one in 2021, and this is, I think, the third event in which there has been this effort to constrain the growth of the program, which is about a $9 billion program, by limiting the number of fiscal intermediaries. For those in that industry, this is shocking, and I think obviously something that everybody's looking at. I'm not aware of any prior proposal of this nature where, this large of a business sector is really eliminated by legislative direction. There is some limited ability to subcontract from the statewide fiscal intermediary, but that probably impacts somewhere between 10 and 20 entities that might have that opportunity. So that's something that, prior initiatives in this space have been litigated extensively, have led to changes. Kristen had mentioned the effective date of the proposals. The effective date of this particular enacted budget proposal is April 1 of 2025. So certainly there's a lot of time between now and then in which I think there will be both legal and political advocacy regarding this. The governor's budget claims a cost savings of around $500 million fully annualized from this change. So it's something that we are going to be continuing to monitor and work on. At Bond, we have a representation of a number of these entities within our client roster. So those are the three items that I wanted to highlight. I know my colleague Gabe Oberfield will be on next week talking about some of the broader health-related changes that were enacted in the budget, and certainly deferring to him and his, I'm sure, excellent presentation at that time.
Thanks, Roger. You're right. You're right. There were a lot of questions, so I'm feverishly typing here to try to answer them. But I want to address, before we moved on to the next presentation, I just want to address a couple of them that I think everyone will want to know. First of all, I didn't mention this, but the paid time for breast milk expression is for both private and public sector employers, so that applies to everyone. Versus prenatal leave is just private sector employers, and that does include nonprofits. Just someone asked that question. The other thing is, does this apply to sort of partners, someone who's actually not pregnant but supporting their partner who is? I had that same question. I think based on my reading of the statute, it does not, because it talks about needing leave for the employee's own situation. I don't remember the word they used, but there was language in it that led me to believe that it's only for the actual pregnant individual. Another comment, I think there might have been a typo on the article we published on this in terms of the effective date. It is definitely January 1, 2025, not January 1, 2024. That might have been a typo on my part. We tried to get this out really, really fast, so I apologize if that happened. So many questions. A lot of my answers to these questions are going to be, I don't know yet. Again, this just came out on Saturday and haven't had a chance to really kind of think through all of the issues. And also a lot's going to depend on how our Department of Labor interprets. They tend to add a lot of gloss on top of any statute that's passed. The statute has very bare bones language, and then we the regulatory agency to fill in the gaps for us. So I apologize if some of my answers in the chat here are going to say, I don't know yet. But just better to be honest than to make up an answer. So with that bit of additional information, we're going to stay on the subject of pregnancy. And Stephanie, if you would like to share with us the new regulations out of the EEOC, that would be great. Thanks for being here.
Thanks so much, Kristen. Great to be on the webinar. I will preface my slides by saying there's a lot of content. You will have access to the slides, so I wanted to put it in the slides so that you can refer back as you might want to. But we're going to breeze through this in the interest of time. This is a topic that is very, very comprehensive. It could, be its own webinar in and of itself. And I wanted to really illustrate that there are significant changes, and that the final regulation and final rule for interpreting and implementing the Pregnant Workers Fairness Act by the EEOC is very long. It is very comprehensive. So it's something that you should pay special attention to, because it will necessarily change your operations and how you handle requests for accommodation for pregnancy, childbirth, and related health conditions. Next slide, please, Kathy. So most notably, here's a little bit of background, but these are going to go into effect June 18th, 2024. So you have a little bit of time to become familiar with the proposed, or with the final rule rather, and make any necessary changes to your policies and procedures and practices. If you could skip 2 slides, Kathy, that would be great. So ultimately, the PWFA, you can go on to the next slide, please. Thank you. The PWFA is going to apply to employers that are covered by Title VII. A lot of definitions are borrowed from Title VII and the ADA as well, but I think there's some significant differences with the Pregnant Workers Fairness Act. Oh, you can go back 1 slide. I'm sorry, Kathy. Oh, nope, never mind. Go one ahead. Thank you. So some of the key highlights of the Pregnant Workers Fairness Act, remember, this is a law, the federal law, that requires employers to provide accommodations for qualified individuals, or a limitation, a known limitation, which is going to be defined as a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions that the employee or their representative has communicated to the employer. Note that this does not need to meet the definition of a disability under the ADA. So this is a much different standard. And there's going to be an expansive and very broad interpretation of the types of conditions or limitations that will be covered. The guidance or the rule itself notes that these types of limitations could be modest, minor, or episodic. And they could also be related to maintaining an employee's health or the health of the pregnancy, or seeking care related to pregnancy, childbirth, or related medical conditions. Next slide, please, Kathy. So some of the most significant changes, right, that we will work through are these expansive definitions. With respect to pregnancy and childbirth, that includes current pregnancy, past pregnancy, potential or intended pregnancy, including infertility, fertility treatment, and the use of contraception, labor, and childbirth. Next slide, please. So I'm not going to read every single condition, but these are the list of explicit conditions that the rule considers that could be related medical conditions that could trigger an obligation to accommodate. This includes, I think, most notably termination of pregnancy, which includes a miscarriage, stillbirth, or abortion. Various other common pregnancy-related conditions that you might see on the slide, antenatal anxiety, depression, or psychosis, which is when those conditions coincide during the pregnancy, or postpartum depression, anxiety, or psychosis. Menstruation is another one on the list that is considered as a possible related medical condition that could warrant accommodation or necessitate accommodation. And lactation. Next slide, please. Notably, there's a definition of qualified employee, right? Remember, this applies to qualified employees. That's an employee or applicant who, with or without reasonable accommodation, can perform the essential functions of the job. That should ring some bells because that's pretty similar to our standard under the ADA, the Americans with Disabilities Act, and what we do under New York State law for disabilities. But it goes further and says that an employee or applicant who cannot perform an essential function of the job for a temporary period, if the individual is or is expected to be able to perform the essential function of the job in the near future. And we'll talk about this in a couple of slides, but the biggest takeaway from this is that the EEOC's final rule considers that an employer may have to eliminate temporarily an essential function of the job, which is very, very different from our analysis and consideration for accommodations under the Americans with Disabilities Act or even the New York State Human Rights Law. Next slide, please. So there's a lot of guidance regarding requests for accommodation, including that an employee does not need to be specific in terms of the the medical condition or itself. It can be made orally. The request can be made orally or in writing or by some other effective means. And that obligation to accommodate is triggered when the employee or their representative has communicated this need to a supervisor, manager, someone who has supervisory authority for the employee, or regularly directs the employee's tasks, human resources, or some other appropriate official, or by following steps in the employer's policy for requesting an accommodation. So that will be critical. On my last slide for you, I have an employer to-do list. I love checklists and I love to-do lists because I think they're practical and helpful. But one of my recommendations for this is that you train frontline supervisors, managers, whoever is going to be fielding these requests needs to be updated and educated on the significant changes from this rule, because the employer could face liability by virtue of a frontline manager, misstepping or following their procedure for the ADA accommodations or New York human rights law accommodations, which again is going to be different in significant ways from the PWFA rule. Interactive process may be necessary to determine the appropriate accommodation in certain circumstances. So we'll talk a little bit about that as well. Next slide, please. So generally, right, remember, reasonable accommodations are going to be modifications or adjustments to the job application process or work environment, or the manner in which a job is customarily performed. It's also applicable for an employee to enjoy equal benefits and privileges of employment, like other similarly situated employees without such limitations. And this could also include, again, the biggest difference here that I see is this temporary suspension of an essential function of a job, or modifications that permit temporary suspension of essential functions of the job. Next slide, please. So again, this is a very comprehensive and a non-exhaustive list that the final rule considers that types and examples of reasonable accommodations that might come up for pregnancy, childbirth, and related health conditions. I think importantly, I bolded some of the ones that draw a lot of attention to me, right? Telework, temporary suspension of one or more essential functions of the position, permitting someone to use leave or providing unpaid leave for recovery, as well as treatment. So keep these are non-exhaustive examples that are provided by the final rule, but it really is supposed to be thought-provoking because it's quite an expansive and comprehensive rule, and it's very, very broad. Next slide, please. So there's a list of what I call presumptively reasonable accommodations. These 4 are very common, and the final rule, which is similar, if not identical to the proposed rule, states that you can't ask for documentation to support these accommodations. That's going to be allowing an employee to keep or carry water or take water breaks and drink water as needed. Additional restroom breaks as needed. Someone whose job requires standing a lot should be permitted to sit, and someone who is required to sit a lot should be permitted to stand if they need it. And allowing employees to take breaks to eat or drink as needed. So these are the presumptively reasonable accommodations that will almost in all circumstances be reasonable. And that is very clear and emphasized in multiple parts of the final rule. Next slide, please. So significantly, there's a lot of discussion in the final rule and in the interpretive guidance that comes along with that, which is an appendix to the final rule that provides a lot of illustrative examples of when documentation will be permitted and when it will not be permitted, et cetera. So there's significant limitations on what you can ask for in terms of evaluating these reasonable accommodations. Next slide, please. So there's also very clearly 5 situations that the rule says you cannot request documentation, right? When the limit, most obviously to me, when limitation or the adjustment or change needed is obvious, and an employee provides a self-confirmation, and the self-confirmation just means the employee has to say this is the limitation and this is what I need in terms of the accommodation. When an employer already has sufficient information to determine that the employee has a limitation and needs a workplace accommodation, due to the limitation, when the employee is pregnant and seeks one of those 4 common accommodations on the prior slide that I mentioned already, when an accommodation is related to lactation, you cannot require documentation for that. And when the accommodation is available to employees without known limitations pursuant to an employer's policies and practices, without requiring those folks to submit supporting documentation. Next slide, please. So it's important that to note that train your folks on when documentation is permissible and not to be requested, including this provision that the rule provides that an employer cannot justify failing to provide a reasonable accommodation or an unnecessary delay in providing a reasonable accommodation unless certain circumstances and conditions are met. Next slide, please. With respect to unnecessary delays, there's comment or the final rule provides that an unnecessary delay itself might result in a violation of the law, even if the employer eventually provides the accommodation. And there's going to be several factors that are going to be considered by, say, the EEOC if they're determining whether or not there was an unnecessary delay. Next slide, please. So with respect to that, consider that these things cannot just sit around. It's always a best practice if you request any sort of request for an accommodation to keep it moving and not unnecessarily delay it. Undue hardship. Again, you don't have to provide an accommodation that's going to impose an undue hardship, but this is a high burden to meet, and the final rule includes some very specific factors of what should be considered. Next slide, please. And then some final highlights, right? Remember, these are significant differences and deviations from the ADA interactive process that we're used to and that we know. An employee is not required to accept an accommodation that's proposed, but note that obviously if the rejection results in the employee not being able to perform the essential functions of their job, they might not necessarily be qualified. And a lot of the remedies and enforcement are similar to Title VII. So an employee will be able to bring a claim or a charge of discrimination with the EEOC, might be pursued by the Attorney General. Costs and fees and damages are available for violations. And then next slide should be my checklist for employers of your final to-do. So review and update your current workplace accommodation policies and train decision makers, frontline supervisors and HR on these updates, because I see that being where the liability really might come up, is if someone is not educated on what they can and cannot require, what they can and cannot ask, etc., when an employee has asked for a certain accommodation. So make sure that you do that. And don't hesitate to reach out to legal assistance for clarification through this process or in the future when you're considering accommodations in real time.
All right, thank you, Stephanie. That was a lot, a lot of information, but really valuable. And, perhaps we'll look at doing some more follow-up on that in this program or otherwise from our firm, because it is a lot to get through. But really, really helpful. So thank you, Stephanie, for that. Okay, so last but not least, Andrew Delzaro is here to talk about how our New York State and city human rights law applies to those out of state. Thank you for being here, Andrew.
Hey, everybody, how's it going? Kristen, thanks for having me. It's a pleasure to finally be on the program, so
Great.
That's good. You can go over to the next slide, Kathy. Thanks. So great. As many of you are already aware, New York State protects its residents from discrimination in the job hiring process through its human rights law that's enforced by the Division of Human Rights. So interesting, yet not really surprising. This human rights law, which covers discrimination, was actually the first of its kind in the United States. I'm a history major, so I like to do a little bit of a history lesson. It won't be long, but this was enacted in 1945. And the division was set up the same year to enforce the anti-discrimination law. So there's your fun fact of the day if you didn't have one already. The reason I gave you this little lesson isn't to bore you, but rather to provide some context to better understand the recent development that will definitely likely to, it's definitely going to affect many of your organizations, specifically those located in and around New York City. So back in 1945, the law was limited to just race, creed, color, and national origin. Throughout the years, it was amended to add additional categories that are highlighted on the screen here. As you can see, it's quite substantial. And it's added more protected classes, which has led to more potential claimants, which is kind of the topic that I'm here to discuss today. You might be thinking, well, it covers so much now, it seems impossible to further increase the universe of potential claimants for these discrimination claims that you get through the Division of Human Rights. In terms of these protected classes, you might be right. Only time will tell on that one. And quickly learning to never put anything past the New York legislature. But however, there was some low-hanging fruit still out there that a recent Court of Appeals decision just kind of grabbed with the similar effect of expanding the universe of potential discrimination claimants in New York, and might I add, in quite a substantial way. What I'm referring to here is not a new protected class of individuals, like, age, race, creed, etc., but rather non-residents from outside the state being added into this fold. You can go to the next slide, Kathy. So the case I'm mentioning is Saeed v. Bloomberg Media. This was kind of just decided last month in March. The plaintiff in this case began working for Bloomberg Media as a reporter covering cybersecurity in its Washington, D.C. office in 2014. Then a few years later, in 2018, a position covering the United Nations opened that was based out of their New York City office. So Ms. Saeed applied for the open position and was ultimately not chosen to fill the role. This was not the first time that the plaintiff had applied for an open position with Bloomberg in their New York City office, and she confirmed her interest to relocate to New York City many times throughout her few years being employed there in their DC office. So she definitely made it known throughout the company that she wanted to relocate to that office and that she was constantly seeking job opportunities in New York City. Ultimately, she alleged that she was not selected to fill any of these open positions. Instead, the job was given to a man who she claimed was not as qualified nor as experienced as she was. 2 years later, the plaintiff left the company Bloomberg and filed this action in New York State court as a California resident, alleging sex and race discrimination by denying her promotions. So the defendant, Bloomberg, in this case, removed it from New York State court to New York federal court, where the United States District Court for the Southern District granted the motion to dismiss on behalf of Bloomberg. However, plaintiff appealed, and the Second Circuit reserved its decision and certified the question of whether the New York City and state human rights laws extend to cover a non-resident, basically saying New York courts are more equipped to handle this, so let's have them answer it. And that's exactly what they did. Like I said, in March, they did just that by unanimously ruling that a non-resident who has been discriminatorily denied a job in New York City or state, and I quote here, loses the chance to work and perhaps live within those geographic areas. And they basically said that this is enough to establish a right of action for non-residents actively seeking employment in New York. Essentially, the court decided that neither the New York State nor the New York City human rights laws intended to equip employers with a license to discriminate against non-resident job applicants. So now the case is going to return to the Second Circuit, where it's expected to apply this new ruling. So what does this mean? Or you can go on to the next slide, Kathy. What does this mean for employers within New York State? Pretty simple. Nothing really changes aside from the universe of potential claimants expanding quite a bit. Specifically, employers in New York or in New York City should, make sure and ensure that their hiring practices are non-discriminatory and otherwise compliant with both state and federal law. And in the case of New York City employers, New York City law, because everybody knows New York is the place to be, at least that's what they tell me. And, the state and city discrimination claims are definitely going to increase in and around New York City just because of the sheer volume of people who want to relocate to somewhere in and around New York City and New York State generally. But, being in New York, we get a lot more out of state folks, wanting to work in and around New York City specifically. So, as always, make sure your practices for hiring are airtight. Feel free to reach out to bond attorneys who can definitely help you through that process.
Great, Andrew. Thank you so much for letting us know about that case. Interesting map too. I've never seen that one before. So thanks for sharing that. Want to thank everyone for being here today. Here's all the email addresses for everyone. Many people have asked about the slides. The slides did have a lot of information today to digest. And as always, they are on our website on the events page. There's a whole page devoted to this webinar, and it does contain the slides and the recording for every program. Go there and you can download them. If for some reason you can't do that, you're always free to contact me via email or anyone else here. We're all happy to help. We can shoot you a copy via email. So thank you for being here, and I'll be back again in 2 weeks. Gabe will be here next week talking more about the New York State budget and other topics, and we appreciate your attention. Take care.